Welcome to The Docket. I'm your host, Corey Snow. This is episode 17. In September 2023, Donald Trump submitted a motion to the United States District Court in Washington, D.C., requesting that the judge assigned to his criminal case, Judge Chutkan, recuse herself, alleging that her statements made at the sentencings of various January 6th insurrectionists indicated she was biased against Trump and would be unable to adjudicate the trial impartially. Soon after, the Special Counsel Jack Smith submitted a response to the recusal motion, opposing recusal by Judge Chutkan. What follows is a narration of that response. Please note that legal and statute citations are generally simplified or, when possible, omitted for the sake of listenability. The original document, including all citations and footnotes, is available at a link provided in the show notes. If you enjoy the docket, please consider supporting my Patreon at patreon.com/docketpod, which allows me more ability to pay PACER and other court fees to obtain documents for me to narrate. The defendants in any criminal proceedings are presumed innocent until proven guilty in a court of law. In the United States District Court for the District of Columbia, United States of America v. Donald J. Trump, Defendant. Government's response in opposition to defendant's motion for recusal of district judge pursuant to 28 U.S.C. Section 455A. There is no valid basis under the relevant law and facts for the Honorable Tanya S. Chutkan, United States District Judge for the District of Columbia, to disqualify herself in this proceeding. In service of his motion seeking the court's recusal, the defendant both takes out of context the court's words from prior judicial proceedings and misstates the proper legal standards governing judicial recusals. To support his claim, the defendant cherry-picks from portions of the court's sentencings of two individuals for their crimes related to the January 6, 2021 attack on the United States Capitol. In both instances, the court was appropriately responding to, and ultimately rejecting, a common argument raised by scores of January 6th offenders that they deserved leniency because their actions were inspired by or were not as serious as those of others who contributed to the riot but had not been held responsible, including former President Donald J. Trump, the defendant in this case. The court's statements addressing this sentencing mitigation argument were factually accurate, responsive to arguments presented to the court, and evidenced no improper bias or prejudgment of the current case. In addition, the defendant attempts to apply the wrong recusal standard to the court's statements, where, as here, a recusal motion is based on statements made by a judge during judicial proceedings in response to facts and arguments placed before her. Recusal is warranted, quote, only in the rarest circumstances, end quote, where the statements, quote, display a deep-seated favoritism or antagonism that would make fair judgment impossible, end quote. Lightke v. United States, 1994. The challenged statements fall well short of that mark, and while the defendant seeks to avoid the applicable legal standard by asserting that the court's opinions derive from some source outside of the courtroom, he provides no basis for this claim. Because the defendant's motion fails to establish any bias by the court, much less the deep-seated antagonism required for recusal, the court has a duty to continue to oversee this proceeding. The defendant's motion should be denied. 1. Applicable law. In his motion, the defendant fails to mention that there is a presumption against recusal, set forth the proper legal standard for judicial recusal, or acknowledge the heightened standard that applies here, because the defendant's claims are based solely on the court's comments arising from and in the performance of its judicial duties. The reason for the defendant's omissions is clear. He cannot meet these standards, so he seeks to elide them. Below, the government sets forth the controlling legal principles that establish that the court has a duty not to recuse from this matter. Judges take a solemn oath to discharge their duties faithfully and impartially by, administering justice without respect to persons, end quote, 28 U.S.C. Section 453, and absent evidence to the contrary, judges are presumed to be impartial, SEC v. Bilzerian, 2010. Parties seeking to overcome the presumption against disqualification must meet a high bar, Ibid, quoting Cobell v. Norton, 2003. Thus, when a defendant, as here, moves to disqualify a federal judge on the ground that her, quote, impartiality might reasonably be questioned, end quote, under 28 U.S.C. Section 455A, he may not rely on, quote, conclusory, unsupported, or tenuous allegations, end quote, but must provide, quote, clear and convincing evidence, end quote, which a court should, quote, scrutinize with care, end quote. United States v. Nixon, 2017. Quote, a judge once having drawn a case should not recuse himself on an unsupported, irrational, or highly tenuous speculation. Were he or she to do so, the price of maintaining the purity of appearance would be the power of litigants or third parties to exercise a negative veto over the assignment of judges, end quote. In United States, 1981, see also Bryce v. Episcopal Church in the Diocese of Colorado, 2002. Quote, a judge also has as strong a duty to sit when there is no legitimate reason to recuse as he does to recuse when the law and facts require, end quote. Alberti v. General Motors Corporation, 1984. Indeed, quote, in the wrong hands, a disqualification motion is a procedural weapon to harass opponents and delay proceedings. If supported only by rumor, speculation, or innuendo, it is also a means to tarnish the reputation of a federal judge, end quote. United States v. Microsoft Corporation, 2001, on bank per curiam. The question under Section 455A is whether a judge's impartiality might reasonably be questioned, which is assessed from, quote, the perspective of a fully informed third-party observer who understands all the relevant facts and has examined the record and the law, end quote. United States v. Cordova, 2015, per curiam, cleaned up, and not from the perspective of a, quote, hypersensitive, cynical, and suspicious person, end quote. Nixon, quoting Sensley v. Albritton, 2004. The defendant's sole ground for recusal in this case is the court's statements made during formal proceedings in her courtroom in the course of her judicial duties. There is a higher standard for recusal based on such intrajudicial statements, that is, statements made by a judge while she is doing her job, because a judge's core duties include reviewing facts, responding to parties' arguments, and forming opinions, all while maintaining neutrality and fairness. C. Lightke, describing that a judge may become exceedingly ill-disposed toward a defendant after hearing evidence about him, but not be, quote, recusable for bias or prejudice, since his knowledge and the opinion it produced were properly and necessarily acquired in the course of the proceedings, end quote. Accordingly, the Supreme Court has held that where a recusal motion rests on statements made in a judicial setting and reflect, quote, opinions formed by the judge on the basis of facts introduced or events occurring in the course of the current proceedings or of prior proceedings, end quote, recusal will be warranted, quote, only in the rarest circumstances, end quote, where the comments, quote, display a deep-seated favoritism or antagonism that would make fair judgment impossible, end quote. Ibid. After all, quote, opinions held by judges as a result of what they learned in earlier proceedings, end quote, are, quote, normal and proper, end quote, and, quote, not subject to deprecatory characterization as bias or prejudice, end quote. Ibid. See Ballou v. Leventhal, 2011, quote, the high bar set by Lightke for predispositional recusals makes good sense. If it were otherwise, if strong views on a matter were disqualifying, then a judge would hardly have the freedom to be a judge. End quote. This higher standard applies equally when a court's intrajudicial statements were made in separate proceedings, including proceedings in which the defendant was not a party. The D.C. Circuit made this clear in its decision in United States v. Haldeman, 1976, en banc. There, defendants sought recusal of the judge presiding over numerous separate Watergate-related matters, in part based on statements the judge had made during an earlier, separate trial in which, among other things, he, quote, expressed a belief that criminal liability extended beyond the 7 persons there charged, end quote. Ibid. The circuit found that recusal was not warranted because the grounds for the claim were judicial acts, including, quote, prior judicial rulings or the exercise of related judicial functions, end quote. Ibid. The circuit further stated that the disabling prejudice necessary for recusal, quote, cannot be extracted from dignified, though persistent, judicial efforts to bring everyone responsible for Watergate to book, end quote. Ibid. A fundamental component of, quote, the rule of law is that when a judge learns in his judicial capacity, whether by way of guilty pleas of co-defendants or alleged co-conspirators, or by way of pretrial proceedings, or both, is a proper basis for judicial observations, and the use of such information is not the kind of matter that results in disqualification, end quote. United States v. Bernstein, 1976. Recusal unwarranted where judge, in handling multiple indictments of various co-conspirators, made intrajudicial statements during previous plea colloquies and sentencings, including that the scheme at issue was, quote, terrible, end quote, and that he was, quote, sure this conspiracy has cost society millions of dollars. You cannot close your eyes to these things, end quote. See also Obert v. Republic W. Insurance Company, 2005, rejecting recusal motion where the judge's, quote, comments were based on what he had learned in presiding over related litigation, end quote, and explaining that, quote, the law is well settled that, absent quite unusual circumstances, a judge cannot be recused for views formed on the basis of what he learned in court, end quote. United States v. Therion, 1987, rejecting recusal motion where, at the sentencings of co-defendants, the judge described Therion, who was at the time a fugitive and had not made an initial appearance, as the most culpable, and his conduct, quote, considerably greater than the criminal conduct of any of the defendants here on trial, end quote, because he, quote, got most of the money and got a disproportionate amount of the money that was obtained from the victims, end quote. United States v. Wed, 2021. District Court's intrajudicial comments in the context of co-defendants' impending sentencing were no basis for recusal because a judge, quote, cannot be said to have manifested partiality simply by expressing a view of a particular defendant's culpability based on information that has been presented to the court, end quote. Given the demanding standard for recusal based on intrajudicial comments, a judge's in-court statements based on courtroom proceedings almost never give rise to recusal. Rather, cases where courts have granted recusal motions based on such statements, quote, tend to involve singular and startling facts, end quote. Bailu. In one such example, Berger v. United States, the judge presiding over an espionage trial against German-American defendants stated in court, quote, if anybody has said anything worse about the Germans than I have, I would like to know it so I can use it. One must have a very judicial mind indeed not to be prejudiced against the German-Americans in this country. Their hearts are reeking with disloyalty, end quote. 1921. In United States v. Antar, when the district judge stated at sentencing, quote, my object in this case from day one has always been to get back to the public that which was taken from it as a result of the fraudulent activities of this defendant and others, end quote. He made clear, quote, in stark, plain, and unambiguous language that his goal in the criminal case from the very beginning was something other than what it should have been and indeed was improper. 1995. Overruled on other grounds by Smith v. Berg, 2001. Finally, in Centis Group Incorporated v. Shell Oil Company, the Eighth Circuit found recusal appropriate where the judge, quote, directed profanities at plaintiffs or plaintiffs' counsel over 15 times, end quote, and refused to allow the plaintiffs to present arguments at a sanctions hearing. 2009. C. Bellew, citing Berger, Antar, and Centis Group and noting that, quote, similar examples are, thankfully, not easy to find, end quote. On the other side of the ledger are countless cases in which recusal based on judicial comments was deemed unwarranted, even based on comments that, unlike this court's comments on which the defendant bases his motion, directly criticize a defendant. For instance, recently in this district, a judge told a defendant at a hearing, quote, arguably, you sold your country out. I'm not hiding my disgust, my disdain for this criminal offense, end quote. In Re. Flynn, 2020, en banc, per curiam. The D.C. Circuit found that these statements did not meet the Lightke test, stating, quote, the district judge was not simply holding forth on his opinions. Rather, each of the statements to which petitioner objects was plainly made in the course of formal judicial proceedings over which he presided, not in some other context, end quote. Ibid. Similarly, in United States v. Young, the Tenth Circuit rejected a defendant's request for disqualification where the judge opined on the defendant's obvious guilt, predicted that she would get convicted at trial, and speculated that she would sooner subject herself to contempt of court and jail time than cooperate against her co-defendants. 1995. The Tenth Circuit held that the judge's comments did not indicate, quote, an opinion based upon knowledge gathered outside of the course of judicial proceedings, end quote, and that, considered in context, they did not, quote, display a deep-seated antagonism that would make fair judgment impossible. Ibid, quoting Lightke. See also Ibid, elaborating that the judge's comments did not, quote, show that the judge could not possibly render fair judgment, end quote, or, quote, indicate that the judge was unable or unwilling to carry out his responsibilities impartially, end quote. See also United States v. Allen, 2009, per curiam. Judge did not need to recuse from civil tax matter, even though he directed the government to initiate criminal contempt charges against the defendant and said defendants were, quote, in criminal contempt as far as he was concerned, end quote. Charles A. Wright and Arthur R. Miller, Federal Practice and Procedures, 3rd edition, 2023, collecting cases where recusal was denied. 2. Argument. In 2 of the dozens of January 6th related sentencings over which this court presided, the offenders being sentenced deployed a common strategy. They invoked the defendant and the mob on January 6th in their bids for sentencing reductions, arguing that the culpability of others, including the defendant, should reduce their own. The court responded to these arguments as required by law and rejected them. Now, the defendant's motion seeks the court's recusal for its statements made while discharging this core judicial responsibility, claiming that the disqualifying statements undermine public confidence in the court's impartiality and demonstrate that the court has made prejudgments about the defendant. The court's prior judicial statements do no such thing. Instead, an objective look at them reveals that the defendant's motion takes the court's words out of context in order to manufacture allegations of bias. Because the defendant falls far short of his burden to demonstrate that the court has, quote, displayed a deep-seated favoritism or antagonism that would make fair judgment impossible, end quote, Lightke, his motion should be denied. A. The defendant's motion takes the court's intrajudicial statements out of context. Although the defendant tries to claim otherwise, the court's statements about which he complains are core intrajudicial statements, statements that the court made while performing its official duties in direct response to the arguments before it, and which were derived from knowledge and experience the court gained on the bench. As such, to mount a successful recusal claim based on the cited statements, the defendant must show that they display a deep-seated animosity toward him. The defendant cannot meet this heavy burden. As described below, the defendant's motion omits important context about both of the sentencing hearings in which the court made the cited statements. First, it is important to understand the context of the court's work in the aftermath of the January 6, 2021 attack on the United States Capitol. This court, like all courts in this district, has presided over dozens of criminal cases related to January 6th. And this court, like all courts in this district, gained knowledge about the events of January 6th and insight about the persons charged based on its daily administration of those cases. For instance, the court learned that numerous individuals charged with January 6th crimes attempted to minimize their actions and spread blame to others, including to Defendant Trump and to the mob that each rioter joined at the Capitol. Indeed, the court regularly heard variations of such arguments from other defendants in the form of sentencing memoranda and allocutions before similar claims were made by the defendants in the two sentencing hearings on which the defendant bases his claim of bias. It was with this background that the court conducted the two sentencing hearings from which the defendant isolates the statements in his motion. In both instances, the comments of which the defendant complains were not focused on Defendant Trump, but instead addressed mitigation arguments by defendants before the court at the time, an argument that the court had heard in some variation several times before. As such, when the court's comments are taken properly in context, rather than in the, quote, hypersensitive, cynical, and suspicious, end quote, way that the defendant has cast them, Nixon, they evince no bias against the defendant. In fact, the court's judicial statements reveal that when individuals being sentenced attempted to mitigate their culpability, including by assigning blame to Defendant Trump, the court rejected the argument and responded that it had no bearing on those cases. Furthermore, as set forth below, the court made the statements at issue in the course of the court's performance of its responsibilities to conduct sentencing proceedings consistent with the law, including by considering each of the factors in 18 U.S.C. Section 3553A and making, quote, an individualized assessment based on the facts presented, end quote. Gall v. United States, 2007. This individualized assessment must include consideration of the arguments made by the parties, including any arguments in support of a downward variance from the advisory sentencing guidelines. See, e.g., United States v. Hiles, 2017. Quote, when presented with non-frivolous arguments for mitigation, the district court must consider those arguments before imposing the sentence, end quote, and, quote, must provide a reasoned basis when announcing its sentencing decision, end quote. 1. The court's statements at sentencing in United States v. Palmer. On December 17, 2021, the court sentenced Robert Scott Palmer, an individual who, on January 6, 2021, after attending the former president's remarks at the Ellipse and while wearing a Florida for Trump hat, threw a wooden plank at police officers, sprayed the contents of a fire extinguisher at the officers until it was empty, and then threw the fire extinguisher at them, and assaulted another group of law enforcement officers with a 4 to 5 foot pole, which he threw like a spear at the officers. United States v. Palmer, Government Sentencing Memorandum, IBID, 2021. Statement of offense. Palmer was charged with and pled guilty to assaulting, resisting, or impeding certain officers using a dangerous weapon in violation of 18 U.S.C. Sections 111A and B. IBID. Plea Agreement. In a sentencing memorandum filed before his hearing, Palmer's attorney asserted that he had gone to the Capitol at the behest of the defendant and had been convinced by individuals, including the defendant, that the election was fraudulent and that Palmer needed to take action to stop the presidential transition. IBID. Defense Sentencing Memorandum. 2 paragraphs later in the memorandum, Palmer's attorney argued that the court should, as a mitigating factor, quote, consider that the riot almost surely would not have occurred but for the financing and organization that was conducted by persons unconnected to Mr. Palmer who will likely never be held responsible for their relevant conduct, end quote. See Ibid. The court acknowledged this argument on the record at sentencing, as it was required to do. See Piles. The court first summarized Palmer's argument. In support of the downward variance, Mr. Palmer further refers to the sentencing factors outlined in 18 U.S.C. Section 3553A. Specifically, Mr. Palmer asserts that he was motivated to go to the Capitol at the behest of the former president who had convinced him that the 2020 presidential election was stolen and that his presence was needed at the Capitol to stop the presidential transition. Mr. Palmer argues that his presence at the Capitol on January 6th was the result of his desire to act patriotically and for the good of the nation. This mindset and the, quote, crowd mob effect caused him to assault the Capitol Police that day. He also offers that while he accepts and regrets his actions, it is relevant to consider that any purported architects of the January 6th riots have not been charged with any criminal offense, and that it would be an imbalance to sentence him to an extended prison term while those actors remain free. Ibid. Sentencing Transcript. After providing that summary, the court explained why the argument did not warrant a downward variance, given that Palmer's violent conduct was ultimately an exercise, quote, of his own free will, end quote. And it is true, Mr. Palmer, you have made a very good point, one that has been made before, that the people who exhorted you and encouraged you and rallied you to go and take action and to fight have not been charged. That is not this court's position. I don't charge anybody. I don't negotiate plea offers. I don't make charging decisions. I sentence people who have pleaded guilty or have been convicted. The issue of who or has not been charged is not before me. I don't have any influence on that. I have my opinions, but they are not relevant. And you're correct in that no one who was encouraging everybody to take the Capitol has been charged as of yet, but I don't think that fact means that you should get a lower sentence. The fact is that there are lots of people who agreed with you who didn't like the results of the election, who perhaps thought the election was stolen in some way. They stayed home. You decided of your own free will to leave Florida and come to Washington and go to the rally. That's your right. You're not being sentenced for your political views. When you left that rally and went to the Capitol and saw what was going on and engaged in combat with those law enforcement officers, that's what you're being punished for. So, you have a point that the people who may be the people who planned this and funded it and encouraged it haven't been charged, but that's not a reason for you to get a lower sentence. Ibid. The court then sentenced Palmer to 63 months imprisonment, which represented the bottom of the advisory guidelines range. Ibid. In his recusal motion, the defendant seizes upon statements in the court's ordinary colloquy above and attempts to cast them in a sinister light. In particular, the defendant asserts that the court's required recognition of and response to Palmer's mitigation argument, quote, you have made a very good point that the people who exhorted you and encouraged you and rallied you to go and take action and to fight have not been charged, end quote, and the court's uncontroversial, factual, and legal statement that, quote, I have my opinions, but they are not relevant, end quote, reflect bias against defendant Trump. There is no basis for the defendant's conclusory assertions of bias. Taken in proper context, the court has made the factually and legally accurate statement that the actions of other individuals who had not been charged and whom Palmer claimed were responsible for January 6th had no bearing on Palmer's personal culpability. The court's comments simply demonstrate the court doing its job by stating back to Palmer the argument for mitigation that he had made, including that the defendant had influenced him, and explaining that it lacked merit, since Palmer was ultimately responsible for his own violent conduct. In fact, the court took pains to emphasize that it had no role in, quote, making charging decisions, end quote, no influence on those decisions, and that, As a neutral arbiter, any opinions the court may have are not relevant. Ibid. Footnote 2. In United States v. Ciavarella, the district judge made an extrajudicial statement in which he expressly acknowledged that his, quote, personal opinions were in complete sympathy, end quote, with those of a member of the public who had opined on the severity of the offense and said that the sentence contemplated by the plea agreement was insufficient. Recusal was nevertheless unwarranted because the judge added that his, quote, personal beliefs cannot guide my responsibility and judgments, end quote, which, to a reasonable observer, would sufficiently dispel any appearance of bias. Ibid. 2. The court's statements at sentencing in United States v. Priola. On October 28, 2022, the court sentenced Christine Priola, who on January 6, 2021, surged with other rioters into the Capitol and onto the Senate floor, quote, carrying a large sign reading, "We the people take back our country," on one side and "The children cry out for justice" on the other, end quote. United States v. Priola, July 26, 2022, Statement of Offense. And wearing pants with the phrase, "Make America Great Again." Ibid. Government Sentencing Memorandum. Priola was charged with and pled guilty to obstructing an official proceeding in violation of 18 U.S.C. Section 1512C2, Ibid. Sentencing Transcript. In her sentencing memorandum, Priola, too, laid the groundwork for spreading the blame to others, noting that, quote, after the presidential election, Donald Trump and his inner circle began spreading the word that the election was stolen from him by Democrats and others, end quote, with claims, quote, made on media sources as well as by the president himself that the election system had been corrupted and that the integrity of the election should be questioned, end quote. Ibid. Defense Sentencing Memorandum. Priola's sentencing memorandum then sought leniency for Priola in part because she, quote, played no role of importance, end quote, at the Capitol, and had she not been there, quote, there wouldn't be one change in what transpired. Ibid. At her sentencing hearing, Priola likewise explained that, at the time of her criminal conduct, she believed that the election had been stolen and that, quote, certain politicians or groups have, like, taken over things that maybe weren't supposed to be, end quote. Ibid. Sentencing Transcript. She further represented to the court that the sign she held at the Capitol on January 6th was a reflection of the fact that she believed generally in allegations of corruption that the election had been stolen, and that if the defendant were not president, less attention would be paid to human trafficking. Ibid. Priola and her attorney continued at the hearing to minimize Priola's role in the events of January 6th and spread blame to others. Ibid. Priola's attorney requesting downward variance for her minimal role in the entire event, and Priola stating that she had gotten wrapped up in the emotions and the people around her before ultimately entering the Capitol. In response, the court, again as required by binding precedent, addressed Priola's and her attorney's requests for leniency, based in part on their minimization of Priola's role and the request for a downward variance. And so, while Priola's attorney is correct in that your background didn't involve any criminal activity, the events of that day and the seriousness of those events cannot be understated. This was nothing less than an attempt to violently overthrow the government, the legally, lawfully, peacefully elected government by individuals who were mad that their guy lost. I see the videotapes. I see the footage of the flags and the signs that people were carrying and the hats they were wearing and the garb. And the people who mobbed that Capitol were there in fealty, in loyalty to one man, not to the Constitution, of which most of the people who come before me seem woefully ignorant, not to the ideals of this country, and not to the principles of democracy. It's a blind loyalty to one person who, by the way, remains free to this day. There is no mob without members of the mob, as I've said before. So Priola's attorney made a point in his sentencing memorandum that if we were to take your participation out of that group, that everything would have still happened. Your actions did not materially contribute. But they did because you were there, and people act in ways that they would never act alone when they're with a group or when they're with a mob and when emotions are involved. Ibid. Sentencing transcript. With respect to Priola's sentencing, the defendant's motion focuses on the court's comment to Priola that, quote, it's a blind loyalty to one person who, by the way, remains free to this day, end quote. From this simple statement of uncontroverted fact, the defendant purports to draw the inescapable message that the court believes that defendant Trump should be imprisoned. But the only inescapable thing about the court's comment is that it stated an uncontested and accurate fact in response to a mitigation argument that the court had heard many times before. The court, unlike the judges in Flynn, Therion, and Young, none of whom were recused, did not state that the defendant was legally or morally culpable for the events of January 6th or that he deserved punishment. Instead, as the full transcript of Priola's sentencing hearing reveals, the court was engaged in its judicial responsibility to hear, acknowledge, and respond to Priola's sentencing allocution. An objective observer, fully informed of the record at Priola's sentencing and cognizant of the court's substantial experience presiding over January 6th cases, would understand the court's comments for what they were. The rejection of Priola's arguments and the response to Priola that she, and she alone, was responsible for her actions and was standing before the court to answer for them, while others that Priola may seek to blame were not. Accordingly, the court gave Priola a sentence within her advisory guidelines range. United States v. Priola, 2023 sentencing transcript. B. The defendant falls far short of his burden to show that the court's impartiality might reasonably be questioned. The defendant relies solely on intrajudicial statements in these two sentencing proceedings, and thus he must meet the high burden of proving that the court's cited statements, quote, display a deep-seated favoritism or antagonism that would make fair judgment impossible, end quote. Lightke. The defendant cannot meet this burden. The defendant attempts to evade application of this proper standard by cursorily asserting in his motion that the court's, quote, views on President Trump derive from extrajudicial sources, end quote. He provides no basis for this claim. As described above, in making both of the statements upon which the defendant relies, the court was performing its judicial duties in sentencing other individuals. The Supreme Court has made clear that such intrajudicial statements to which the higher standard applies includes, quote, opinions formed by the judge on the basis of facts introduced or events occurring in the course of the current proceedings or of prior proceedings, end quote. Lightke, see Haldeman, Obert, Bernstein, Wed, Therion. Nor can defendant establish that the court's statements came from some other source than the courtroom, because the record proves the opposite. C. Palmer, 2021 sentencing transcript. Court telling Palmer that his mitigation argument is, quote, one that has been made before, end quote. Priola, 2023 sentencing transcript. Court describing to Priola the videotapes and footage the court has viewed and that inform its understandings of the events of January 6th. Because the defendant cannot point to any statements expressing actual bias, all he can say, and he says it repeatedly, is that the court's comments suggest some sort of bias or prejudice toward the defendant. Quoting recusal motion, quote, Judge Chutkan has, in connection with other cases, suggested that President Trump should be prosecuted and imprisoned, end quote. Ibid. Quote, Judge Chutkan similarly suggested that, in her view, President Trump was responsible for the events of January 6, 2021, end quote. Ibid. Quote, similarly, Judge Chutkan's statement that I have my opinions suggests that, in her view, formed almost 2 years before the initiation of this matter, President Trump should be charged, end quote. Ibid, quote, Judge Chutkan's statement suggests that President Trump has culpability for the events of that day and should not be free, end quote. Ibid, quote, her comments suggest that she reached a conclusion before this case that President Trump is more deserving of a term of imprisonment than the defendant she was sentencing, end quote. Ibid, quote, most reasonable observers would understand Judge Chutkan's statements as a suggestion that President Trump may and should be prosecuted based on those facts, end quote. But the defendant's reliance on inference and innuendo fatally undercuts his claim. That is because, quote, when intrajudicial behavior is at issue, manifestations of animosity must be much more than subtle to established bias, end quote. Lightke. Instead, it must typically involve the sorts of, quote, singular and startling facts, end quote, displayed in Berger, Antar, and Sentis Group. See Bellew. With his, quote, conclusory, unsupported, and tenuous speculation, end quote. Nixon. The defendant fails entirely to establish that the court's statements demonstrate any animosity toward him. Tellingly, the defendant does not cite a single case in which recusal has been warranted on remotely similar facts. Instead, he quotes general legal propositions from cases that either have no bearing on the facts of this case or that undercut his request for recusal. One involves the denial of a recusal motion despite gratuitous and inflammatory judicial comments made in front of a jury and targeted at a defendant on trial. See United States v. Nickel, 10th Circuit, 2005. Denying recusal, where the district court, quote, analogized homosexuality to illegal drug use during voir dire, end quote, in a case involving a gay defendant, quote, interrupted the prosecution's closing argument to rebuke the defendant's partner and eject him from the courtroom, end quote, and refused to instruct the jury about the ejection because, the judge stated, the ejected partner was, quote, in effect the defendant's wife, end quote. Others involve recusal claims stemming from straightforward conflicts of interest. See Enri al-Nashiri, 2019, finding recusal necessary where military judge, while presiding over the defendant's case to which the Justice Department was a party, secretly applied for employment with the Justice Department. Hall v. Small Business Administration, 1983, finding recusal necessary because magistrate judge's law clerk had been a member of the plaintiff class. In Re Kensington International Limited, 2003, remanding for recusal-related discovery, where the court had hired court-appointed consultants, some of whom allegedly had an interest in related litigation. Still other cases relied upon by the defendant involve personal or familial relationships. See Cheney, declining recusal request based on a recent vacation the justice took with a named party, Microsoft Corporation v. United States, 2000, Rehnquist, C.J. and Chambers, declining recusal while acknowledging that, quote, my son is one of the attorneys working on, end quote, related litigation. Potashnik v. Port City Construction Company, 1980, finding recusal necessary where the presiding judge was involved in business dealings with and was being represented by lead trial counsel. Parker v. Connors Steel Company, 1988, finding recusal necessary in light of close familial relationship between law clerk and senior partner in the firm representing one of the parties. None of these cases provide support for the defendant's demand for recusal under the circumstances presented here. The defendant cites only one case in which a court found that recusal was warranted on the basis of a judge's statements. But that case, United States v. Microsoft Corporation, D.C. Circuit 2001, undermines the defendant's position rather than supports it, because the judge's extrajudicial statements in that case are so easily contrasted with this court's in both content and setting. In Microsoft, the district judge presiding over an antitrust case in which Microsoft was a party engaged in a series of extrajudicial statements in the form of public speeches and secretive media interviews while the case was still pending. Ibid. In these interviews and speeches, the judge not only engaged in crude characterizations and frequent denigrations of one of the parties, emphasizing, for example, quote, the company's prevarication, hubris, and impenitence, end quote, the judge, quote, also secretly divulged to reporters his views on the remedy for Microsoft's antitrust violations, end quote. Ibid. By contrast, the court's two statements here were factually accurate intrajudicial statements made in the course of sentencing proceedings of other defendants, and neither of them evince bias, much less the deep-seated antagonism necessary to justify recusal. 3. Conclusion. The defendant has failed to identify anything approaching the clear and convincing evidence necessary to overcome the presumption of impartiality. Nixon. Instead, he has relied on suggestion and innuendo to insinuate something sinister in the court simply doing its job by addressing sentencing arguments. The court's comments, when viewed in context by, quote, a fully informed third-party observer, end quote, Cordova, do not remotely, quote, display a deep-seated favoritism or antagonism that would make fair judgment impossible, end quote. Lightke. The court thus has a duty not to recuse itself from this case and should deny the defendant's motion. Respectfully submitted, Jack Smith, Special Counsel, by, signed, Molly Gaston, Thomas P. Wyndham, Senior Assistant Special Counsels. Address omitted. This concludes episode 17 of The Docket. I hope you enjoyed this episode. For updates on the docket, please visit docketpod.com or find us on Threads and Instagram as DocketPod. If you enjoyed this episode, please consider subscribing to the docket and supporting my Patreon at patreon.com/docketpod. Thank you very much.